good afternoon. Thank you so much for joining us today at the Ready for Life Digital Festival. My name is Kishan from CPF Board, and together with me, I have Seow Ling here as well from Eden Law Corporation. Sally, would you like to introduce yourself?
Yeah. Hello, I'm a family lawyer, so I've been in practice for about 9 years, and I specialize in family law as well as estate matters.
All right, yeah. So today we are actually here, to talk about legacy planning and CPF nomination. So, in this festival, digital festival, we have been going through a lot of, activities and also, a lot of things that you can do as passions for your retirement years. So as much as we delve deep into, finding our passions for retirement, I think it's important to think about the tomorrow that comes after that as well. So that's what exactly we are here to talk about today. All right. So. Maybe I'll just start with some questions that I have. So, Seow Ling, ever since I joined the board, right, I have a lot of opportunities meeting a lot of CPF members and also my family members as well. So, of course, I've become their one-stop shop CPF service center at home as well. So they have a lot of questions that they ask me about CPF. And I think an important part of those questions is about legacy planning and also CPF nomination. So I've actually collated some of these questions, and I think we will want to address the questions today. Yeah. Okay, so the first question that I have is for Seow Ling, all right. So we hear this term legacy planning, all right, but what exactly is legacy planning?
Okay, legacy planning, actually there's no definition of what it is, but generally people understand it as a management and distribution of assets upon death. So that can include things like will, CPF nomination, and insurance nomination. But when I do legacy planning for my clients, I like to tell them that, legacy planning, of course, it involves distribution and management after your death. But during your lifetime, you have to ensure that you manage it properly, right? Or you accumulate the wealth so that when you are no longer around, there is something to distribute. So when I talk about legacy planning, usually I will also talk about in financial strategies, right? So it's a financial planning as well, like what kind of insurance to get, how should you use your CPF and things like that. And so it's an ongoing exercise that is during the lifetime. When life circumstances change, from time to time it should be reviewed.
Interesting. All right, so I think we've got a broader picture of what legacy planning actually is. I think another thing that maybe it's not exactly under the umbrella of legacy planning, but I noticed that is commonly discussed with legacy planning is actually the lasting power of attorney.
Yes.
So what exactly is the lasting power of attorney?
Okay, lasting power of attorney, or LPA for short, is basically a legal document where you, as long as you're above 21 and you still have the mental capacity, you can choose a person called a donee to act on your behalf when you lose mental capacity. So the person that you choose must also be above 21 and of course must have mental capacity. And the types of decisions that the donee can make for you are two categories: personal welfare and property and affairs. Yeah.
Got it. And I think, of course, this person has to be somebody responsible as well that you can trust, right?
Correct. Definitely someone that you can trust. So it can be family, friends. Some choose professionals if they don't have anyone that they think they can appoint.
Okay, I think maybe you answered my next question as well. So I was actually about to ask you, what do you think are some pointers that we can take note when, thinking of who we can appoint as a LPA for ourselves, So I think, like you said, our family or friends, or if we think that, maybe there's somebody who may not be suitable, we can look for professionals as well.
Yeah, correct. So usually when I talk to my clients about who to choose, I will ask them to first think who they can trust the most, right? It may not be the closest to you in terms of blood relations, right? Some people, they really trust their cousin, they really trust a long-time childhood friend or something like that. So number one, who do you really trust? Then the second point is, this person that you can trust, do you think he or she is good at making decisions, right? For example, personal welfare decisions such as healthcare treatment, maybe that person can decide. But how about financial? This person may be very close to you, you really trust this person, but maybe he or she is not very good with money. So I've encountered some clients who choose to appoint someone close to them as a personal welfare donee, and they appoint a professional as the donee for the property and affairs.
I see.
So people do choose professional for various reasons. Might be that they want to avoid family disputes. For example, you have 3 children, one of them you think might not be so suitable, but you don't want to appoint the other 2 because you are worried that that one child who is excluded will feel, imbalanced about it. So they'll think, okay, how about to avoid all the disputes between the siblings, just appoint a professional. Yeah, so various situations why people choose professionals. But I always start with asking, who are the people you can trust?
Got it. All right. So my next question for you is, should my LPA be done by a doctor or a lawyer?
Okay, you know I'm a lawyer, right? So who will you choose?
I'll choose you.
Me specifically, is it? Okay. So thanks, but anyway, for LPA, if you want to make an LPA, you have to visit a certificate issuer.
Okay.
So this certificate issuer can be a psychiatrist, a doctor accredited by the Office of the Public Guardian, or a practicing lawyer. Okay. So if you want to look for a doctor, you might be thinking maybe there's a family doctor whom you are familiar with. You you can go to that doctor, but you have to check first on the list whether this doctor is one of the accredited ones. But how to choose? Usually I'll ask, when I give talks and all that, I always tell the attendees that number one, okay, if it depends on the level of service you need. Okay. Right? So if you don't know what an LPA is, you perhaps need more information, you want to ask about other things like will writing and other legal issues, like maybe some family disputes and things like that. Or your donees may have some questions. Because you appoint a donee, your donee may ask, so what am I responsible for, right?
Correct, yeah.
And so your donee might want to also speak to someone who can explain all these things. Then I would think that you have to go to a lawyer, right? So you get those legal advice. But if the donor and donee, they are very familiar with the document, maybe they've attended like 10 talks, or they attended the talk today and they are very clear, right? What is it about? Then they might want to look for a doctor because it's nearby, because there's a long list. You can probably find one that's near to your place, so it's convenient. For psychiatrists, then the specialists, right? Usually people go to the psychiatrist because they might have been diagnosed already with some condition that may affect their mental capacity. So for example, dementia, right? But in the early stage, that person may still be able to make decisions. Yeah, just maybe slightly forgetful and things like that. But to be safe, go to a psychiatrist so that a psychiatrist can do an assessment first. Yeah.
Okay.
So I would say really depends on your needs, what level of service you need.
Got it. All right. So the next question I have is, what will happen if a person loses mental capacity without registering an LPA before?
Okay, so if you do not have an LPA, do you have? Have you done one?
After today.
After today, okay, can. So I'll check on that after today. Okay, so LPA, if you have not done one, a person who loses mental capacity without LPA will basically have no appointed person, right? So in order for the family members or whoever who is interested in helping this person to handle his or her assets or personal welfare decisions like healthcare, medical, this interested person will have to apply to court to be appointed. So instead of getting the power from the donor, the person who makes the LPA,
Court is the one that makes
court is the one who gives the power. So I mean, I'm sure most people know court procedures, it can take quite some time. There's a lot of paperwork involved. Yeah. So basically you have to go to court and you will have to state clearly what kind of powers you need, and also one very big issue that we encounter when doing a deputy application, especially for elderly, is that all relevant persons have to agree to it. So relevant persons are people who are interested in the care of the person who has lost mental capacity. So the default categories are parents, spouse, children, siblings.
Okay.
So I've encountered cases where my client comes to me and say, oh, my mother has lost mental capacity, I need to help her rent out her HDB flat, for example, because now she's in a nursing home. Then I'll tell that person, okay, can you look for your uncles, aunties, your mother's siblings, and then your other siblings who must all sign a consent to agree that you apply.
Okay.
I said, I don't even, I only see them during Chinese New Year, or maybe we haven't even been in contact for a long time. Yeah, so that at the start will really form a problem. And if let's say they really cannot, then that's something we have to declare to court and let the court know. And we'll send the documents to them. And in the documents, there are a lot of private information, like your financial information, how much you earn, do you have any debts? And then for the person who has lost mental capacity, you also have to declare what assets this person has. Yeah, so a lot of private information which a lot of clients would not be comfortable releasing, but that's just a requirement. So definitely to save the effort, or rather save time and cost for your family members, register an LPA.
Yeah, I think something that comes to my mind right now, because I'm in my 20s right now, and I think I come across my peers who are also around the same age group, and I think that sometimes it does not come to our mind immediately to do such things or make such arrangements right away. Yeah, but I think what you said resonated in a sense that, it's not just about you, but about making the process easier for your loved ones in the event that something unfortunate happens.
Correct.
Yeah, so I think that, in that sense, it's also our responsibility to take that effort ahead for them as well.
Yes.
Yeah, so yeah, I learned something new today. Yeah, so in the case that I've already made my LPA, right, but maybe, I mentally reviewed the decisions that I made and I want to revoke it. Is there a way that I can revoke the LPA?
Yes, definitely. So for the LPA, as long as you still have mental capacity, you can revoke the LPA. But for LPA, in order to revoke it, you have to notify the donee. So the persons that you previously appointed have to be notified. They don't have to consent, but they must know.
Okay.
Yeah. So it can be notification through, even I've tried before, like WhatsApp, and then we just show proof that it has been sent to this person.
Okay.
Yeah. Yeah.
Right. Okay. Yeah. So I think I think this also helps make that that gives that comfort that making that decision is not a permanent decision. If circumstances change, we can actually revoke it.
Yeah.
If we want
Because
to.
like I mentioned, legacy planning is something that you have to review from time to time.
Yes.
You can't take it that I just want to wait for that time when I can decide what's going to happen in the future. Nobody knows, right? So you do something now so that any time when something happens, according to your current circumstance, it is something that you think is suitable, right? But over time, it may change. For example, if like you buy a new house, right? Or you have one more child, or you have a grandchild and you want to provide for this grandchild, right? So different circumstances, over time, you should review your plans from time to time to make sure that it is suitable.
Yeah, I agree with that. I think year on year itself, some of our circumstances change, Yeah, so I think it's very, very important to review regularly. All right. So, I know I'm going to throw many situations at you, So, yeah, okay, now we know that, you're able to revoke, right? So, what happens, right, if I do not revoke, but if that professional donee, right, actually goes missing after I've lost mental capacity?
Right. So, you see, when you do an LPA, and you have a donee, whether professional or not, there may be a risk there, right? That the person that you appointed for some reason cannot continue to help you when you lose mental capacity, right? So same for professional donee. If the person decides to choose a professional donee and for some reason, for example, the professional donee decides to quit his or her job, or something happens, then yes, there will be no more. So that's why we always encourage people to choose a replacement. Right? Okay. So you may appoint a professional donee as the first choice.
Okay.
You can have a replacement professional donee. So that in case the first one cannot continue, the second one can step up.
Okay.
Or some people appoint their own family members as the first choice and then the professional as the second choice. Right? But worst case scenario, really all the persons that you have appointed all cannot continue, then you will fall back to a deputyship. The court order way.
Okay, got it. Sure. All right, the next question is, are there other situations where my LPA or donee's powers will be cancelled? I think this is a very interesting one.
Yeah, okay, so this is related to what I mentioned just now, right? You don't know, whoever you appoint, there is a risk that your LPA cannot. So I think cancelled in the sense that, okay, so if you appoint donees, if the donee is your spouse and you go through a divorce, then yes, that person's appointment will be cancelled, okay? Then for any kind of donee, if that person loses mental capacity himself or herself, that person passes away, then it will be cancelled. For property and affairs, if the person becomes bankrupt, or the donor becomes bankrupt, then the LPA cannot be used for property and affairs, right?
Okay.
So unless you have a replacement donee to replace that bankrupt donee, otherwise then the property and affairs portion will not be covered. Yeah,
Okay.
so those are the situations. But of course, I'm sure you have seen in the news as well. Possible other situation is that when the donor's registration is invalid, in the sense that maybe when at the point of registering the LPA, the donor actually did not have the mental capacity. So those are the ones that you see on the news where they dispute and things like that. That's why it's very important to choose the level of service that you need, right? When choosing which certificate issuer to go to witness. So if a person, like I said, has already been diagnosed with some condition that affects mental capacity, best to go to perhaps a psychiatrist where a mental capacity assessment can be done first, so that later on, if there's a contest, the LPA can be defended to say that at that point in time, yes, this person has the mental capacity.
Got it. So I think it's so important to actually think about the multiple stages where, the LPA will be, used to, consider when you want to set that LPA up. Right?
Correct. So it's important to do it early when you're still alert, you're still healthy. Do all the planning so that you don't end up waiting until the last minute when something has already happened. Then there's some uncertainty and things like that, and then the cost will go up as well.
Correct. Yep. All right, the next question is an LPA donee allowed to change our will or CPF nomination?
Okay, simple answer, direct answer is no. LPA donee cannot do will or CPF nomination changes. Insurance nomination also cannot be changed. So there are certain excluded decisions in the Mental Capacity Act where the donee cannot do these things. For example, that person also cannot, for example, change your advanced medical directive, cannot change your option under the Human Organ Transplant Act and things like that. So there's a whole list of excluded decisions. So that includes the will and CPF nomination, cannot be changed by the LPA donee.
Is there a website or resource that we can refer to for this list?
Yeah, that's the statute. That's the Mental Capacity Act. Or actually the Office of the Public Guardian website is very informative as well.
Okay.
So anything related to lasting power of attorney and deputy, you can go to the Office of the Public Guardian website.
Thanks for sharing that. Yeah, and I think, like you mentioned, CPF nomination as well.
Yeah.
The LPA donee does not have the rights to change it. Actually, only the court has the capacity to do it. Probably the only rights that is given to the LPA donee is actually the information, access to the information about the
Correct.
CPF nomination.
Correct.
Yep. All right. So yeah, I think here it's somewhere I think I can share a bit more about CPF nomination. Yeah. So I think we all hear about CPF nomination quite regularly, but I think I just want to bring you through what exactly is CPF nomination. Probably you're a pro yourself. You probably know it very well as well.
My turn to ask you questions.
Yeah. So CPF nomination, right? It's actually an arrangement where you can actually specify who you want to give your CPF savings to and how much you want to give how much of those savings you want to give them to upon your passing. All right. It actually cannot be included in your will, right? The CPF savings. So it is actually because your CPF savings does not form part of your estate. Why? Do you know?
Yeah, it's protected for the family members. Yeah.
You probably
I did my homework. Okay.
Yeah. So it's actually really to protect your CPF savings against creditor claims. Most importantly, it's actually left for you, left for your loved ones actually upon your passing. So that's why it does not form part of your estate and therefore cannot be willed. All right. So let us actually understand what is covered under a CPF nomination, what is not covered. All right. So firstly, your CPF nomination covers CPF savings in your ordinary, special, MediSave and retirement accounts, right? So that means all of your CPF savings. Because I've heard some people say that maybe your MediSave savings is not covered, but actually it covers all of your CPF savings, all right? It also covers any unused CPF life premiums that you have and discounted Singtel shares. What it does not cover is, it does not cover properties bought using your CPF savings, any payouts from the dependent protection scheme, and also investments made under the CPF investment scheme. So for the properties, right, the treatment is actually, the treatment of the deceased share is actually dependent on the manner of holding. So if the property is under joint tenancy, ownership of the property will be transferred to the surviving owners. If the property is held under tenancy in common, then the deceased share of the property will form part of his estate. All right, so with a CPF nomination, right, you can actually decide who you want to give your CPF savings to upon your passing, and how much you want to give to each of them or each of your nominees. You also would be very happy to know that making a nomination is free. It's a free process. I mean, I hope, after today's sharing, if you have not made a CPF nomination yet, you will go ahead and do it right away. All right? And it's also a very easy online process. Yeah, I mean, you'll be wondering, why am I asking you to do a CPF nomination on a Sunday, right? It's because you can actually do it online. You do not have to go into our service centers to do it. You can do it online. I'll share a bit more about that later. But before you make your CPF nomination, here are 3 considerations that you need to take note of. All right, so firstly, you need to decide who should receive your CPF savings and how much. I think it's similar to, making decisions in the context of legacy planning as well. I think for me, I always think about who are my dependents. For example, like maybe just to share on a personal note, I think for now, I'm not married yet. I don't have my own children yet. So although I'm still living with my parents, I think the first in line would be my parents. They would be my dependents. Yeah. But of course, once I get married, once I have children, once I have my own family, these situations may change. Correct. Yeah. So I think it's for us to take some time to think about who we want to give our CPF savings to, and what proportion of the savings we want to give to each of them. Next, you will actually have to decide on 2 persons to actually act as the witnesses for your CPF nomination. So actually, their job here, right, is just to attest that you have done your CPF nomination in a sound mind, all right? So you don't have to worry. I think some of you may be worried, in terms of legal obligations that's, attached to the witnesses. So for example, if you're not able to contact the witnesses anymore. So actually, after they have completed that process of witnessing, right, affirming your intention to nominate, right, the job is done actually. Yeah. So I hope that helps you make a decision on who you want to appoint as your witness. Thirdly, you can actually choose to authorize specific persons to access your CPF account information upon your passing. So actually, without this explicit authorization, right, your account information or even your nomination decisions will not be revealed to anyone, including your nominees as well. So if you want this you want this information to be known by someone, you got to make that indication when you make your nomination. So you got to think about that as well before you make your nomination. All right, so now that we know what a CPF nomination is, what it covers, just take note there are some requirements as well before you make a CPF nomination, but very simple requirements actually, all right? So you got to be a CPF member to begin with, and you got to be at least 16 years old. And at the time of making the nomination, you got to be mentally sound as well, which is where your witnesses will help to attest that as well. All right, maybe I also wanted to share this very interesting thing that I heard in a conversation I had with my friend recently. So he was chatting with me and he said, hey, upon passing on, right, my CPF savings will just go into my nominee's CPF accounts, right?
Oh.
Yeah, so right. I didn't know it won't be, but he was so certain. He said, no, CPF savings will go into the CPF, the CPF savings of CPF accounts of my nominees. Yeah, so maybe there might be a misconception that he has, right? So I just want to remind everybody that by default, your CPF savings will be given to your nominees in cash. So actually, upon your passing, within 15 days, the CPF board will contact the nominees to come forth and make a claim for the CPF savings. All right. And how can you make your CPF nomination? Like I said earlier, you can actually use our online nomination service, which I highly, highly recommend. And there's also an option of using the CPF service centers or going down there to make your nomination physically. All right. But, really, enjoy the convenience, of making the CPF nomination anytime, anywhere. I think we're all very busy people.
Yeah.
So I think that, you would have spent some time making the decisions that I asked you to make earlier. So, take some time, use the comfort of your home to make the CPF nomination online.
I've done mine as well, and I organize CPF nomination parties with my friends.
Wow.
So like, you have a group of friends together, and then we'll say, hey, have you done your CPF nomination and things like that, and then we'll say, okay, whip out your phone, and then I witness for you, you witness for me. Yeah, because actually most of the time, most people would already know who they want to give the monies to.
Okay.
It's just whether they take the action of actually stating it down.
Okay.
Right? Same for will and LPA.
Correct.
They already know who they can trust. It's not that difficult to decide. It's just whether they want to take the extra step of having that in writing or doing the legal procedure. But most people don't do it, thinking that it's very cumbersome, it's costly and things like that. But yeah, CPF nomination, in fact, when people come to me for estate planning, this is the first thing that I ask them. I say, have you done your CPF nomination? Because that's like the easiest thing you can do in this whole estate planning thing, right? In this whole process. So yeah, I think that, if you haven't met your friends for a very long time, because of COVID or whatever, you can organize CPF nomination parties, and then you all can help each other to witness your nomination as well.
Do you all nominate each other also?
No. We nominate our own family.
I thought inviting myself for the party, if that's going to be the case.
No.
Right.
No.
Yeah, but that's very interesting. I think it's also a way
As
to kind of like
witness,
encourage one another to
Correct.
because I think for me as well, when I was actually going to make the nomination, right, I never thought about it until when I joined CPF board.
Okay.
So when I wanted to make the nomination, I realized there's an online nomination service, and truthfully, it took me 5 minutes. Yeah, because I already, like you said, I already had the decisions in mind already, and it just took 5 minutes, and then my witnesses received an SMS to notify them that you can go and affirm your intention, affirm the person that notified you, which is me. Yeah, and it was completed very, very fast. Yeah. So yeah, maybe I'll just bring you through that entire process to let you know how simple it is. All right. So what you need to actually prepare is very simple. All right, your SingPass. Okay, most of you guys should have your SingPass with you, I hope. Yeah. So you have your SingPass details with you, and then the full name of your nominees as per their identification cards. Also their identification numbers, their mailing address, and also their email address. All right. Then you need to actually have 2 witnesses as well. Similarly, the details that you see on the screen, you got to prepare that as well. But do take note that your witnesses cannot be your nominees. So these have to be different individuals. All right, so now the very easy step. You just log into our online services, CPF online services, with your SingPass to make your nomination online. All right, so if you got a pen and paper, you can just take note of this URL, cpf.gov.sg/makecpfnom. All right, so this URL will bring you to our online nomination service, and you can very simply follow the very simple steps there and make your nomination. Trust me, it will just take 5 minutes. All right, so next is you got to inform your witnesses of your intent, to verify your intention to nominate, because I mean, if you don't inform them, they're just going to get a random SMS
They
and
might think
that
it's a spam.
but so this they either get an SMS or an email notification, but they may not know, like, hey, was it you making the nomination?
Correct.
Or was somebody forcing you to make the nomination? So this is where you call them, inform them, hey, I've decided to make my nomination. Will you be able to verify my intention to nominate? Yeah, so that's all you need to let them know, and then they can just log in using their SingPass as well. So at this stage, maybe it's good to remind you that for your witnesses, right, they need to have their SingPass details with them as well, because they need to use their SingPass to log in to verify your intention to nominate. So take note of that when you're deciding on your witnesses. Right? And within seven calendar days, CPF board will actually CPF board will contact them immediately, and within 7 calendar days, they got to verify your intention to nominate, and process is done.
Yeah.
Very simple. But of course, if you wish to actually go to our CPF service centers, that's possible as well. You can actually book an appointment, but you got to book an appointment. So you got to book an appointment at least 1 day before going down to the service center. Bring along the details, that I shared earlier, your identification cards, and as well as photocopies of your nominees' identification documents as well. And then you can complete your CPF nomination there. And for the witnesses, actually our staff at the CPF board will be able to act as your witnesses there as well. So you do not need to think about your witnesses if you're going to the service center. But then, right, I think all of you guys are logged in virtually today. So I'm very, very confident. I think you guys are definitely tech savvy. So why not
Right.
take advantage of our online nomination service, and then enjoy that convenience, and you do your nomination anytime, anywhere actually. Yeah, so I highly encourage you to do that. Okay, so Seow Ling, now I've already done my nomination. Is it done?
No.
Don't you think it's anymore?
Like what I mentioned just now, right? All your estate plans and all that you have to review from time to time.
Correct, yes. So similarly for nomination as well, we got to review our nomination regularly. It's not a one-time off thing, all right? So maybe some key milestones will be during your marriage, during your childbirth, I know an unfortunate event of a divorce,
Yeah.
and also an unfortunate event of a death of a nominee, yeah. But do take note that only during a marriage, right, your nomination is automatically revoked. So in case you already have an existing nomination and you have gotten married recently, you have to go and make a fresh new nomination as well, because your family nucleus might have changed, and your decisions may have changed, all right? So go and make that new CPF nomination.
So like for yourself, if now you have nominated your parents, when you get married, that's automatically revoked,
Correct.
right?
Yes. Yeah.
Okay.
So I think I got to think about, maybe at that point in time, my wife would be our dependent as well. So I would have to include her into my, my legacy planning efforts as well. Yeah. So, if I have children in the years as well, got to include them as well.
Okay.
Yeah. Okay, I think this question may come about what happens if one of my nominees pass away before me.
Okay.
Yeah. So I think for CPF nomination, right, it is pretty straightforward in a sense that if let's say you have decided on a proportion, maybe you have 4 people, you have given 30%, 30%, and 10% to one individual. So in the case that the person who is given 10% passes away, his share would be distributed in proportion to the rest. So in this case, all 3 of them, the 30%, 30% equal, right? So the 10% will be divided into the 3 and given to them for CPF nomination. But let's just say, in terms of intestacy law, is there any things on that side of things as well?
So usually when my clients come to me, I tell them that, for example, if your main beneficiary is your spouse, right? Instead of putting 100%, you put maybe 99%, and then you have a 1% for this other person who is the replacement nominee in that sense. So that if let's say your spouse is still around, worst case scenario, that 1% only gets 1%, right? But if your spouse is no longer around, then that 1% gets the 100%. So that's more straightforward. But for people who say, I really don't have that 1% person to appoint, then I'll say, okay, never mind, you put 100% to your spouse, but do know that if your spouse also passed away or already passed away before you, then the default Intestate Succession Act distribution will apply. Okay. So in a case where a person is married without children, if the parents are still around, then the parents will get 50-50.
Okay.
Right? If this person has children, then the children will get in equal share. So basically, it's either if there are children, then children have priority. If no children, then parents will get in equal shares. Yeah.
So is this the same arrangement if let's just say someone does not have a CPF nomination?
Yes.
This
correct.
is the same arrangement that will take effect as well. All right. So, sometimes we actually share our wishes, with our family and friends, that, hey, after I'm gone, you get this,
Right,
So, when these are all loved ones that we're all very, very close to, and we are confident that they will honor our wishes as well. But even in that circumstance, why is it important to write a will if we can just simply rely our wishes to them?
Okay, so like I mentioned, right, number one, so the basic thing, like you said, you believe that your family members will honor what you have told them. But number one, what you have mentioned to them, is it clear enough? Right? Did you scope it properly? Or do you just say, roughly I have this bank account, I use it to distribute to A, B, C.
Yep.
But you might have missed out some other assets, right? So you may end up with incomplete instructions. But more importantly, even if you trust the people, at this point, I always say you never know, right? Life circumstances change for yourself as well as the people that you have entrusted your instructions with and your beneficiaries.
Yeah.
So if you tell this person, okay, when I pass away, I want you to distribute this way. 10 years down the road, does this person still remember what you said?
Yeah.
Is this person still as trustworthy as you thought
Yep.
10 years ago? So for lawyers, I mean, I guess the topmost consideration is, does what you did, does it have any legal effect?
see.
Right? So definitely if you have certain instructions, it's best to have it in writing. And of course do it the proper will way. Like, same thing, you have two witnesses, but for wills we have to do it physically. So the witnessing has to be in person.
Okay.
Right? Then number two, like I said, evidence of the instructions, right? So you tell them, even if they really, really intend to carry out your instructions, they may have forgotten what you said, right? Where do they refer to?
Yep.
Then next thing is that if you tell to one person,
Correct.
and this one person say, okay, I promise you I will follow your instructions. But when this person helps you to distribute the assets, the people receiving the money will say, hey, why am I only receiving this much? I should have gotten more or something like
Sounds
that.
like a plot for a Korean drama.
It really happens. I think they get the inspiration from real life cases.
stories.
So how do you evidence the instructions? So it's not just to uphold what your wishes are, but also to protect the person who is helping you to do the distribution. You see, so the evidence of the instructions. Then just now we have mentioned a few times, you review your estate plan from time to time, right? So I think when in the process of doing out these legal documents, something I see my clients go through is that they actually put their mind to the planning process, right? And when they give their instructions to the lawyer will be able to advise them on whether their ideas are workable, whether it's practical to maybe arrange things in a certain way. So for example, I have clients who say, oh, I want to use my will to distribute my CPF.
Okay.
Right? So they might have that thinking that, oh, I can just verbally tell someone or write my will and not do my nomination. But that's not true, right?
Correct.
But if they speak to a professional and say that I want my CPF to be nominated this way, can you write it in my will? Then I'll tell them, sorry, CPF nomination, you have CPF, you have to do a nomination.
Right.
You can't include it in your will, see? So I think it's getting the legal advice on whether your wishes are workable and whether it's practical. Right? And then at the same time, last point is that when you talk to a professional about the planning, and you plan in advance, that's when you have the time, the luxury of time to consider your options. Right? So for example, for people with family members with special needs, they may speak to a lawyer and the lawyer say, are you sure you want to give your money directly to this beneficiary, knowing that this beneficiary does not have the mental capacity or perhaps not best placed to handle this money himself or herself. So that's when I'll maybe recommend other options, such as the special needs trust fund, right? Instead of writing a will to say, I give 50% to my child who actually has special needs, I say 50% will be deposited in my child's special needs trust fund, which has to be set up separately. So you have that luxury of time to do your planning. I had a case recently where I was called in to do a will for a person who only has like a few days left. I mean, that's according to what the doctors say. So quickly we went down to his house. At that point, then I realized that he has properties without mortgage insurance. He has not, nominated his CPF, has not done this, has not done that. So I try to do as much as I can, but because of the very tight time frame, right, I didn't have time to go through like a comprehensive planning.
I see, okay.
Yeah, so then when he passed on, about like 2 weeks later, his wife had to run around and because he was the main breadwinner, it was very difficult for the wife to get all these things in order. Yeah. So if you know your things best, so if you do the planning in advance, that can save your family members time and effort, especially in times when they're actually grieving.
Yeah. So I think what you said also, I think steps into the next question that we have as well, whereby, I think something that I think I got from what you were saying is also it gives a peace of mind for our loved ones.
Correct.
So in that context, so if let's say someone doesn't have much assets, right? Is there an importance of writing a will? I mean, I think some of the pointers you shared earlier would also
Correct.
be relevant to this as well. Yeah.
Yeah. So my answer to this, definitely I will say, if you do not have much assets, still you should do your will, because it is very clear how you want to distribute the whatever little assets that you have, right? But one thing I realize is that a lot of people think that they don't have much assets, but they actually forget about their HDB flat. Yeah, a lot of Singaporeans, they have HDB flat. They do not see it as asset because they don't see the cash, right? But actually, that forms part of the estate. So as long as you have a HDB flat, even if it's like a 3-room flat or even something that's under lease buyback, you can get like maybe 5 digits, right? So that's something that is valuable, and most importantly, it is your something that you are giving to your family and your loved ones, for them to know that you thought of them, and this is something that you want to give to them. And also think about the insurance claims that you may be entitled to. I mean, touch wood, for example, personal accidents. A person passed away because of accident, there may be accident claims, and then it can be quite a huge sum. So how do you want this amount to be distributed? Yeah.
Right. All right, so maybe let's see if we have some time to take some live Q&A questions as well. All right, I think I have some questions for you. How to identify a professional donee? What are the charges like?
Okay. Okay, so professional donees, there's a list of us. So we had to go through some training course, and then we had to do some exams, and we have to register ourselves. So on the Office of the Public Guardian website, you can actually find that list of our names, people who have been registered as professional donee. In terms of charges, it really depends on the person that you approach, because on that list there are social workers, there are accountants, there are lawyers. So it really, again, depends on the service that you need. Right? Do you need a lawyer? Maybe because there are certain family disputes, potential family disputes, or you have spoken to one of the lawyers and you're comfortable with this lawyer to be your professional donee, provided that lawyer is registered as a professional donee. Yeah. So the charges are different. I would say that it ranges from like maybe 200 plus to it can be a few $100. Yeah. Depending on how senior, how experienced that person is as well. Yeah.
Would I get a friendship discount if I find you?
Yeah, sure.
Thanks.
Take this offline.
Right. So the next question is, for the LPA, would it be a conflict of interest if they are already in the will as well?
No conflict of interest. In fact, it's quite in line. If you have an, I guess you are talking about LPA donee being a will beneficiary. In fact, it makes sense because you see, during your lifetime, your assets are managed by your LPA donee if you lose mental capacity, right? So if during your lifetime, your LPA donee doesn't manage your assets so prudently, or let's say needs to sell off certain assets, then later when the will kicks in, certain distribution may be affected. So a donee who is also a beneficiary under the will, it actually is in line, because I would think that the donee should be more prudent, right? And careful in the usage of the money. But ultimately, for LPA, when the donee makes decisions, it has to be in the best interest of the donor.
Okay.
Yeah, so the person has to think in terms of what is best for the donor, what is best, not what is best for himself or herself, right? But definitely in terms of naming a donee in the LPA and in the will, that's fine, right? If you are worried about the donee thinking about his or her own interest and being very stingy on you, not spending money on you so that he or she inherits more later on, then my question is, can you really trust this person if you have this worry? If you have this worry, then perhaps this person is not best placed to be your donee. You might want to consider a professional instead.
All right. The next question is, can LPA be challenged by persons of interest?
I'm not sure what persons of interest this question is referring to, but I would think that yes, LPA actually can be challenged by anyone who knows of certain circumstances, right? Like for example, they saw the child kind of like threatening the elderly mother outside the clinic or something like that. Yeah, definitely it will be good to actually raise this up to the Office of the Public Guardian to whistleblow. Yeah.
I see, I see. So, another reminder to, think about who we want to give these responsibilities to as well when making this documentation. Right. The next question is, my sister is my donee. Can I ask her spouse to be a witness for the LPA document? Is there any conflict of interest in this circumstance?
Okay, the good news is that the LPA is going online starting tomorrow.
Yeah.
So you need your SingPass. So when you choose a donee, you can use the it's the Office of Public Guardian online. So you go to the portal, you use your SingPass to draft the LPA, then you put in the donee's information. The donee will be informed by SMS or email, and the donee can log in with SingPass to sign without a witness. Yeah, so you just have to confirm through the SingPass. So you don't actually even have this witness issue. Yeah, but if really your donee needs legal advice, like I said, then your donee can actually go with you to see the certificate issuer. But there's no need for donees to have witnesses.
Got it. All right. I think the next question, you briefly, I think addressed it earlier also, but I think we have quite a number of queries on this. Maybe we can address it again. Can a person with mild dementia do an LPA?
So I think it depends on how mild is, because it's really a whole spectrum, right? So like I said, if a person has already been diagnosed with some kind of condition that potentially affects that person's mental capacity, it is best to go to a psychiatrist or a doctor so that they can also assess whether this person still understands the document. If you go to a lawyer, technically we can do it too, but I think that it is more relevant for a doctor or psychiatrist to do it.
I see. Got it. Okay, I can see a bunch of questions on CPF nomination coming in. The first question is, will CPF e-witness get to see the details of the nomination? I believe when you say e-witness, is probably somebody who had actually done an online nomination and indicated the witnesses. So the witnesses would not be able to see the information that you have indicated in your nomination. So it actually ensures enhanced privacy for you as well, because with the hard copy process, right, inevitably sometimes if someone is signing, they may see the information. Yeah. So with the online service, there's a certainty that they won't be able to see the information. The next question is it possible for a CPF officer to be the witness for CPF nominations? Yes, so CPF nomination can be witnessed by CPF officers if you were to go down to the CPF service centers to actually go and do your nomination. Yeah, but then I highly encourage you to still use our online nomination services, because I mentioned in the earlier question, right, the privacy is really, I think that's the best form of privacy as well. I mean, in case you don't even want the CPF officer who's arranging it for you to know the details at that juncture, you using the online service will eliminate that as well. All right, so the next question is, why must I bring copies of the nominees' NRIC? I do not want the nominees to know. All right, actually the copies of the NRIC, right, is only to complete the form. Yeah, we actually do not actually give them the details, so just because these details are provided to us, we do not send across your nomination details as well.
Yeah, but you don't actually need the IC copy, right?
Yeah.
So, because I remember I brought, I think one of the clients in the past, before the online thing, my client only needs the person's IC number.
Yes,
right?
yes,
not
correct,
the
correct.
IC copy.
Correct,
right?
yes, you need the IC number to actually go and make the nomination at the service center.
Okay.
All right, so next question is, how much does it cost to do an LPA? I think you briefly shared earlier as well. Maybe
so for LPA cost, actually the cost is just the certificate issuer, the person that you are approaching to witness you sign the LPA. So it really depends, like I said, again, the level of service, right? So for example, if you go to a psychiatrist, usually the cost is higher. Depends on how much that psychiatrist charge usually, right, to see a patient. Doctors, for GPs, there's also a range, depends on which clinic you go to. So for myself, I did it at clinic, so I actually called up a few around my house to ask about their costs.
Okay.
Yeah, so you call up and then you say, do you do LPA, confirm that you're on the list, how much do you charge, right? Then for lawyers, it also there's also a range, because like I said, it depends on why you're going to them, right? So if you go to a lawyer because you have a huge bunch of questions to ask about LPA and you expect to be spending like a 3-hour session with the lawyer, then of course the cost is going to go up. Yeah, so really there's a range. You can go online, go to the Office of Public Guardian website, look at the list of certificate issuers, and you can call up to ask, right? Then there is also the registration fee. So when you register at LPA, there's actually a registration fee. There's a different fee for Singaporean, PR, and foreigners. Okay. So for Singaporeans, it used to be $75, but it's waived until March 2023. Yeah.
It's good news.
But don't wait until like 29 March 2023, then you start to panic. Please just do it as soon as you can. But anyway, the registration fee for the Office of Public Guardian is waived until end of March 2023. I think it's 31st March 2023. But if you are a PR, then there's a registration fee of 100. If you are a foreigner, then it's 200. From what I can remember, 200 or 250. Yeah.
Great. Okay. The next question is: can the non-donee children challenge the professional donee if they feel the donee is not doing his duty professionally or doing it poorly?
Yeah, definitely.
I think you mentioned the case of if someone's mistreating an elderly.
Correct. So be it professional or non-professional donee, if there are people who witness or suspect, like for example social workers and all that, right? Or even doctors, they see bruises and things like that. So if there's a suspicion that the donee is not doing his or her job well, be it the donee is professional or your own family member, that person can be complained against.
Got it. I think the next question is really quite interesting. Can a video recording of the person's wishes be used as a will?
No, cannot. Stop trying to save money. Just do a will. Okay, so I always tell people, right? You see, when you do a will, it's like your last statement. Correct? So don't save money on that. Do up something properly. Don't just use video or like some other ways. The clear way, only way is please do a will, and best to do it with a professional. When you are no longer around, your will is your last statement. Okay, that will be opened up, and then your family members will know what your distribution is. But the thing is, by then you are no longer around. Who's going to defend or explain why you decided this way? So it's best if you have spoken to a professional. The professional should have written down your instructions, perhaps chit-chat with you, understand your rationale for certain distribution, what was the advice given, and that person who has advised you can then be your defender, right? To uphold your wishes. Yeah. So don't just like do a video and things like that. Anyway, that's not a valid will. Yeah.
I can just imagine what happens if the video got accidentally deleted. Depending on that.
Correct. Or it can be actually doctored, edited, right? Because now, they can even put a person's face on like somebody else's body. I mean, it's just dangerous. Anyway, just do it properly.
Yeah. I think we can take the last question for today. Do we need to inform all of our children that an LPA has been made?
No. So when you do LPA, when you do wills, all these, or even CPF nomination, you don't have to inform anyone that you don't want to, right? So will, you can do it without telling anybody, but it doesn't make sense because then who's going to carry out your instructions, right? So for that, you can speak to a lawyer. But for LPA, you only have to let your donee know because your donee needs to sign the LPA. Other than that, you don't have to let anybody know. But I always tell people, all this planning, it is part of a conversation that you should have with your family members. If you foresee that some people may contest, it may be helpful to tell them that this is your wish and be firm about it instead of just hiding. Then later when something happens and your donee takes over, they start to fight and you are not able to defend your decision anymore, right? So it may actually be better to be upfront, even though yes, you don't have to tell them about it.
All right, thank you so much for sharing. I think on a personal note, I just wanted to also say, I think this may be some difficult conversations to have or difficult thoughts to have, but it does not need to be intimidating or difficult. I think just take some time, think about what you want to do, and of course document these wishes properly. It gives you the peace of mind, also gives your loved ones a peace of mind. And if it's something that you can do today itself, you can actually make your CPF nomination, and we highly encourage that. All right, so thank you so much for joining us today. I think it was really fun having you with us today as well. Thank you so much, and I hope you guys enjoy the rest of the festival. Goodbye.